Hi students, welcome to another Mr. Ness screencast. Today's aim is Schenck v. US, and here are your objectives. Please pause the video, look these questions over, and get ready to copy some vocab terms and take some notes. Civil liberties are basic freedoms that are guaranteed by the first 10 amendments to the US Constitution, which is also known as the Bill of Rights. Take a look at this image. You probably learned these amendments in the first semester of US history. The civil liberty that we're going to focus on today is freedom of speech, which is a right guaranteed by the First Amendment. The First Amendment says that Congress shall make no law abridging the freedom of speech or of the press. Today, you are going to learn about the government's decision to restrict the First Amendment during World War I, and about a major court case that resulted from that decision. Civil liberties always get restricted during wartime, and World War I was no exception. So in 1917, just after the US entered World War I, Congress passed a law called the Espionage Act. And the Espionage Act made it a crime to disrupt the draft or otherwise undermine the US war effort. This law was broadly defined, and it wasn't long before it was being used to arrest people whose actions would have been perfectly legal during times of peace. One of those people was Charles Schenck. Charles Schenck was a socialist who disagreed with US participation in the war. Remember, socialists thought that the working classes were being exploited by the rich, and Schenck argued that World War I was really being fought for the benefit of rich business owners, who made money selling weapons, and who hoped that a war would bring them new colonies. But it was the poor, not the rich, who had to fight and die in the war. And Schenck thought that this was unfair and unjust. He started passing out pamphlets on the street, small booklets of information. And his pamphlets encouraged people to protest the war by resisting the draft. So Schenck was saying, in other words, that if someone got drafted, they should refuse to go and fight. Schenck said that this was their right. Here's what Schenck's pamphlet said. Assert your rights. You have a right to assert your opposition to the draft. To draw this country into the horrors of the present war in Europe, to force the youth of our land into the bloody trenches of war-crazy nations, would be a crime. To advocate the persecution of other peoples through the fighting of a war is an insult to every good and wholesome American tradition. You are responsible. You must do your share to maintain, support, and uphold the rights of the people of this country. In response to these pamphlets, the police arrested Schenck and accused him of violating the Espionage Act and another act called the Sedition Act. And the government said that by encouraging people to resist the draft, Schenck was, quote, undermining the US war effort, just like the Espionage Act forbade. Schenck then sued the government, and his case went to the Supreme Court. The result was one of the most important Supreme Court cases in US history, and it's called Schenck v. US. You've learned some important Supreme Court cases already, like Marbury v. Madison, Dred Scott v. Sanford, and Plessy v. Ferguson. Now I want you to add Schenck v. US to that list. In this case, Schenck v. US, Schenck argued that he had a right to pass out his pamphlets because he was simply exercising his freedom of speech, the First Amendment. But the Supreme Court ruled against him, and in doing so, they created an important rule that is still used today to decide when the government is allowed to limit citizens' free speech. And this rule is called the clear and present danger rule. The clear and present danger rule says that citizens are not allowed to say things that create a, quote, clear and present danger to the well-being of the country. The Chief Justice of the Supreme Court at this time was named Oliver Wendell Holmes. Here he is on the right. And here's what Oliver Wendell Holmes said. The most stringent protection of free speech would not protect a man in falsely shouting "fire" in a theater and causing a panic. The question in every case is whether the words used create a clear and present danger, that they will bring about the substantive evils that Congress has a right to prevent. When a nation is at war, many things that might be said in times of peace are such a hindrance to the war effort that their utterance will not be endured so long as men fight, and no court could regard them as protected by any constitutional right. Look at Holmes's analogy of fire in a crowded theater. If someone yells fire in a theater, they're using speech. Fire is just a word. But it could cause a panic or a stampede, and people could get killed. So Holmes says that in this case, people should not be allowed to yell fire, because it creates a clear and present danger to others. And using the same reasoning, he argued that Schenck's pamphlets, which again are just words, were creating a danger to the country by encouraging people to resist the draft. If everyone resisted the draft, there would be no soldiers to fight, and the US would lose the war, which could be dangerous. What do you think about that? Can words be dangerous? If so, should the government make it a crime to say them? Also, were Schenck's pamphlets creating a clear and present danger? Why or why not? These are tough questions, and they're the reason why the Supreme Court case and the clear and present danger rule are such a big deal. All right, it's time to review the objectives. If you don't know the answer to any of them, just rewind the video and look again. And I will see you in class. Bye, students.